Imagine for a second, just picture that you were working as a bank teller.
Okay.
And suddenly, an armed robber walks right up to your window, slides over a note, and, demands all the cash in your drawer.
Right, a terrifying situation.
Exactly. You are completely terrified. Your brain registers this legal threat, and you completely freeze.
Which is a totally natural response.
Right. So you hand over the money without throwing a single punch, without screaming for the security guard. You don't try to wrestle the weapon away. You just comply.
Because you want to survive.
Exactly. But then, when the police finally arrive, they don't even look at you. They just close their notepads and say, well, you didn't physically fight back, so we have to assume you actually wanted to give the bank's money away. No crime here.
That would be insane.
It would be completely absurd. We don't expect a bank teller to physically fight an armed robber just to prove a robbery occurred.
No, of course not.
And yet, for a very long time in our legal system, the law demanded exactly that kind of physical struggle when it came to a different, deeply personal crime.
Yeah, it really did.
So here is the core legal problem we are unpacking for you today in this deep dive. How does the criminal justice system handle sexual assault cases when the victim, paralyzed by a physiological response known as frozen fright, fails to physically resist, and the attacker uses no explicit threats?
It's a heavy topic, but an incredibly important one.
It really is. Why was sexual assault treated so differently from crimes like robbery for so long?
Well, it is a profound question, and to answer it, we have to look at how the law fundamentally misunderstood human biology for decades.
Right.
To truly understand how we got to where we are today, we're going to trace this massive legislative evolution.
Okay.
We'll look at how the archaic, frankly, deeply flawed resistance requirement was finally dismantled.
Oh, it changed everything, right?
It did. It shifted the legal focus away from physical combat and toward the victim's actual will and genuine fear.
Got it.
And to really anchor this for you, we are going to walk through a pivotal California Supreme Court case, People v. Iniguez.
I'm looking forward to getting into that one.
Yeah, it's the case that practically forced the lower courts to finally accept the reality of psychological trauma.
Okay, let's unpack this historical paradigm before we get to the specific case, because the context here is just wild to me.
It really is.
To appreciate the shift, we really need to look at what the baseline was. So what was the state of the law before things changed?
Well, to understand the modern rule, you have to look at the general rule prior to 1980 in California.
Okay, pre-1980.
Right. Under Penal Code Section 261, the law was remarkably strict and, honestly, highly skeptical of victims.
How so?
It defined rape as an act of sexual intercourse, where a person physically resists, but that resistance is overcome by force or violence.
Wow.
Or, alternatively, where a person is prevented from resisting by threats of, and this is the exact language, great and immediate bodily harm, accompanied by an apparent power of execution.
Wait, so the burden was entirely on the victim. It sounds like the law essentially assumed a victim must engage in mortal combat to prove they didn't consent.
Yes, exactly.
Like, if you didn't fight back, the assumption was just that it was consensual.
Precisely. The law essentially demanded resistance as corroboration.
That's incredibly harsh.
It was. Historically, the justice system harbored this deep institutional distrust of sexual assault claims.
Wow.
Treating a lack of physical struggle as a presumption of falsity was the system's way of filtering out what they viewed as potentially fabricated charges.
So they needed proof of a fight.
Right. You either had to show physical bruises from a fight or prove you were facing an overwhelming, explicitly articulated threat of severe violence, like literally a weapon held to your throat.
But that completely ignores how the human body actually reacts to extreme trauma.
Completely.
I mean, we all know about fight or flight, but science tells us there's a third, equally powerful biological response, right? Freeze.
Exactly. And that is what finally triggered the critical shift in 1980. The legislature finally started looking at actual psychological and biological studies.
About time.
Yeah. These studies demonstrated that when faced with an overwhelming, terrifying threat, the parasympathetic nervous system can essentially override the body.
So it's not like you're making a conscious choice to just lie there.
Not at all. It is not a conscious choice. The brain assesses that fighting or fleeing will result in greater harm, so it initiates a shutdown.
That makes total biological sense.
Right. Many women respond to sexual assault not with active physical resistance, but by freezing, becoming entirely helpless, numb, and paralyzed by panic. It is an evolutionary survival mechanism.
So once the lawmakers finally accepted this biological reality, How did the law actually change?
So in 1980, the California legislature amended Section 261, and it was a seismic shift.
Okay, what did they do?
They completely eliminated the physical resistance requirement.
Wow, just completely.
Gone. The new general rule became this. Rape is an act of sexual intercourse accomplished against a person's will by means of force, violence, or fear of immediate and unlawful bodily injury.
I noticed a shift in the language there, too. It went from requiring a threat of great bodily harm to just unlawful bodily injury.
Yes, good catch. The standard for the threat level was lowered significantly.
Why did they do that?
By changing great to unlawful, the law finally acknowledged the reality of frozen fright. It meant courts could recognize that a victim might be terrified of any violent escalation, not just lethal force.
That's a huge difference.
It is. For the first time, the law assigned the decision of whether to physically resist an attacker to the realm of personal choice.
So bringing it more in line with other crimes.
Exactly, bringing sexual assault into conformity with other crimes, just like your bank teller analogy earlier.
Right.
The focus shifted from, well, why didn't you fight, to, was this taken against your will?
Okay, that makes so much sense. So let's analyze People v. Iniguez to see how this played out. First, what are the legally dispositive facts?
Well, this takes place in June 1990. We have a 22-year-old woman, Mercy P.
Okay.
She was petite, weighing about 105 pounds, and it was the night before her wedding. Yeah. She arrived at the home of Sandra S., who was a deeply trusted family friend. Mercy actually considered Sandra an aunt. Sandra had even sewn Mercy's wedding dress.
So this is an environment where she feels completely safe.
Exactly. We are talking about an environment where Mercy had an incredibly high expectation of safety.
And the defendant, Hector Iniguez, was also there, right?
Correct. Hector was Sandra's fiancé.
Ah.
He was a much larger man, weighing approximately 205 pounds, or nearly double Mercy's weight.
That size difference is definitely going to matter.
It does. That evening, he was described as tipsy, having consumed a pint of Southern Comfort and several beers.
Oh, wow.
And it is important to note that the court record shows absolutely no flirtation or romantic interaction between him and Mercy.
Right. Nothing at all. So around midnight, Mercy goes to sleep in her clothes on a sleeping bag in the living room. And then, between 1:00 and 2 a.m., the assault happens. She wakes up to find the defendant, completely naked, approaching her from behind. He pulls down her pants and inserts his penis. And this is where that biological response we talked about kicks in. Mercy suffers profound frozen fright.
She absolutely did. At trial, she explicitly testified that she was utterly terrified of a violent reaction if she moved or made a sound, so she laid completely still.
She just froze.
Yes. The assault lasted about a minute. Afterward, her post-assault trauma was severe and immediate.
She didn't just quietly leave either. She fled the house, hid in the bushes outside because she was terrified he would come looking for her.
Right.
She found her friend and literally asked if the word rape was written on her face. She was experiencing this desperate, trauma-induced urge to scrub herself clean in a shower.
And the defendant's response when he was later arrested is incredibly revealing here.
What did he say?
He admitted to the unconsented act, but his defense hinged entirely on the old way of thinking. He claimed there was no force or fear.
Are you kidding?
No. He explicitly stated he was just taking advantage, in a drunken way, of a situation where somebody appeared to be out of it.
Wow.
He essentially argued, she didn't fight me, and I didn't hold a knife to her, so how can it be rape?
Which brings us directly to the analysis. And what was the core legal issue?
The issue was this. Was there sufficient evidence that the act of sexual intercourse was accomplished by means of fear of immediate and unlawful bodily injury to sustain a rape conviction, given that the defendant made no explicit threats and the victim did not physically struggle?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule governing the fear requirement under Section 261, Subdivision 2. The rule has two distinct elements.
Okay, what's the first one?
First, a subjective component, meaning the victim genuinely entertained a fear sufficient to induce submission.
And the second?
Second, an objective component, meaning the fear was reasonable under the circumstances, or, if unreasonable, the perpetrator knew of the subjective fear and took advantage of it.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the subjective component?
So the sub-issue here is, did Mercy genuinely fear immediate bodily injury?
Right.
The sub-rule is that the extent or seriousness of the injury feared is immaterial. Also, subjective fear can be inferred from the circumstances and post-attack conduct, despite an attacker's lack of explicit threats.
Okay, so how did they apply that to Mercy?
Well, applying the facts, Mercy explicitly testified she froze out of fear of a violent reaction.
Because she was terrified.
Exactly. The court looked closely at her post-attack actions. Fleeing into the bushes, her severe distress, asking if she looked like the word rape was written on her face, and her desperate urge to shower.
So what did they decide?
The court's conclusion was that the subjective element was easily met. She genuinely feared injury.
Understood. Now what about the second element, the objective component?
The sub-issue for this element is, was Mercy's fear objectively reasonable under the totality of the circumstances? The sub-rule states that reasonableness is measured by weighing both the acts of the attacker and the response of the victim, looking at things like size disparity, location, and surprise. And crucially, it does not require the victim to scream or resist.
So how did the court apply this one? I know there's some wild history with the lower court here.
There is. The Court of Appeal had falsely claimed the fear was unreasonable simply because she didn't scream for her aunt in the next room and he didn't verbally threaten her.
That's awful.
The Supreme Court aggressively struck this down as a violation of the 1980 amendment.
Good.
Applying the facts, the Supreme Court noted this was a 205-pound man attacking a 105-pound sleeping woman in what should have been a highly secure environment.
Right, a close friend's home.
Sudden, unconsented to groping and intercourse while sleeping is, in the court's words, an appalling and intolerable invasion of autonomy.
Absolutely. So what was their finding?
The conclusion was that the Supreme Court ruled any person waking up to this scenario would reasonably react with fear. The objective element was overwhelmingly met.
And after analyzing all the elements, what was the court's final conclusion?
Because both the subjective and objective elements of fear were satisfied, the Supreme Court reversed the Court of Appeals decision, reinstating the defendant's original conviction for rape.
Well, that's a relief. But here is where it gets really interesting, and I want to push back on a specific nuance of the rule you laid out.
Sure, go ahead.
You noted that the objective component had an interesting caveat. Or R, if the fear is unreasonable, the perpetrator knew of the subjective fear and took advantage of it.
Yes, that's a very specific part of the rule.
So let's test that caveat. Imagine an attacker knows a specific victim has an intense diagnosed clinical phobia of cotton balls.
Okay, a cotton ball phobia.
Yeah, a completely harmless object. The attacker corners the victim, holds up a handful of cotton balls, and silently implies, "Submit to me or I'll cover you in these."
Right.
To a normal jury, the fear of bodily injury from cotton balls is objectively absurd. It's totally unreasonable. So how does the law handle that under this rule?
That is a phenomenal hypothetical. Under a strict, traditional, reasonable person test, the objective element would instantly fail. No reasonable person fears severe bodily injury from a cotton ball.
Exactly, so it wouldn't be rape.
Well, this is exactly why the 1980 amendment and the Iniguez court's articulation of the rule are so vital. Even though the fear fails the standard reasonable person objective test, the attacker knowingly exploited a subjective, genuine terror to bypass the victim's will.
So because he weaponized her specific phobia.
Yes. Therefore, under the rule outlined in People v. Iniguez, this satisfies the legal requirement for fear.
Wow, that's fascinating.
It perfectly illustrates how the law prioritizes the overarching principle here, protecting the victim's free will against calculated exploitation. It doesn't matter what the weapon is, as long as the attacker knows it works on that specific person.
That really clarifies it. So to wrap this up, I want you to synthesize everything we've discussed today into a practical diagnostic toolkit for the listener.
I can definitely do that.
How can they use this when evaluating future cases or hypotheticals on an exam?
So, here is your 4-step diagnostic checklist. Step 1, check for physical resistance.
Okay, start with the obvious.
Right. If resistance is overcome by force, it's rape. But if there is no physical resistance, immediately trigger the post-1980 analysis.
Got it. What's step 2?
Step 2, test the subjective element. Did the victim genuinely freeze or submit out of fear of bodily injury?
I mean, look at the circumstances for that.
Exactly. Your checklist here is to look for circumstantial evidence, psychological frozen fright testimony, and post-event trauma indicators like hiding or feeling dirty.
Okay, step 3.
Step 3. Test the objective element, prong A. Would a reasonable person fear injury?
The totality of the circumstance.
Yes. Evaluate weight and size disparities, location, violation of a safe space, and the element of surprise.
And finally, step 4.
Step 4. Test the objective element, prong B. If the fear seems totally unreasonable, did the attacker possess specific knowledge of that fear and deliberately weaponize it? If yes, the rule is satisfied.
That is an incredibly helpful framework. Thank you for breaking that down. But before we go, I want to leave you, the listener, with a lingering question that builds on this concept of frozen fright, but pushes it even further.
Okay, what is it?
If the law has successfully evolved to recognize that a psychological freeze negates consent, how should it handle situations where a victim is medically paralyzed or unconscious?
Oh, wow.
Right. In those scenarios, they are experiencing absolutely no fear at all because they are completely unaware, yet they are utterly deprived of their will.
That's a profound point.
Does our legal definition of force and fear need to evolve yet again to protect those who cannot even feel fear in the moment? It is something to seriously think about as you continue to study this area of law.